I started the recording.
Okay. I'll go ahead and share my screen then too, okay?
Sure.
So now it's set up. Can you see that?
Yes.
Okay.
I'm going to turn off my mic.
Okay. Oh, I see. So we have 25 participants, but so I won't be able to see them though, right? Because it's set up as a webinar. Okay, I got it. Okay, I'm Shawn Joost, and it's 1:30, and so I'm gonna go ahead and just get started with some introductions. I'm I'm used to doing these as where I can see the other people, so but there were so many of you, which is great that we had such a great turnout, that it's a Zoom webinar. So I'm assuming you can all hear me. And if we want to communicate, you can communicate questions through the question and answer box. As I said, my name is Shawn Joost. I'm an employment law partner at a Sacramento law firm, Murphy, Austin, Adams, Schoenfeld. And I've been volunteering for SCORE for about 1.5 years, although this is the first presentation I've done for the Capital Corridor chapter. So I'm really excited to be here today. We're going to talk about new laws in the employment world and updates in the law from the last year that you need to make sure that you as an employer are ready to go this year. Some of them are going to be things that you just need to be aware of. Some of them are going to be things that require you to update your employee handbooks or other policies, or have new types of postings and communications with your employees. So I hope that you will find today's presentation to be practical and useful. As I was saying to the woman who organizes this for your SCORE chapter, you know, I really love doing these presentations because so often employment law areas and wage and hour areas are overlooked when people are starting a new business. And I love to be able to help small business people get those systems set up properly, because it will sure save you a lot of difficulties in the future if you can get it set up right at the start, and it may save you a lot of money too. So this is my legalese disclaimer here. The recording started before I think they opened the webinar, but just so everyone is aware, they are recording this presentation, and you will be sent a copy of the slides and I believe access to the recording link as a registrant for the session. There's me. All right, so here's today's agenda. We're going to go through some wage and hour updates, talk about some updates in discrimination, harassment, and retaliation. We're going to talk about some changes in leaves of absence and a new statutory leave of absence, some workplace safety, that'll include some COVID updates, changes in employee arbitration agreements, a little mention of something in employee benefits, and then my favorite part of my annual year-end update, the top 5 things that we thought employers knew but learned they didn't. So those are things that came up in my practice this last year, or one of my colleagues' practices last year, to sorry, now I'm seeing a question. I'm going to be honest, it's a challenge sometimes for me to do the presentation and monitor the question. So if your question's sitting there, I'll get to you, but I may have to wait until I come to a natural break. But anyway, the top 5 things are things that came up in our practice over the last year, which were things that we said, oh my gosh, we thought all of our clients knew that, and we learned they didn't. So some kind of a review. All right, so let me go up to the Q&A box. Will we be given copies of the slides? Oh, I have to type the answer. I'm assuming you all can hear me too, right? So, but the answer is yes. They will be circulating the slides, and I believe the link to the recording as well to everyone who signed up. Okay, now let me close out the question box. So we're going to start out with some wage and hour updates, always important in California. So minimum wage this year for all employers in California is $15.50 an hour. That's the statewide threshold. Now, some of you may be operating in other localities that have their own local minimum wages, and I can't go through all of those in this presentation, but you might want to check if you are, especially if you're over in the Bay Area, you may have a local minimum wage that you need to comply with too. But the statewide minimum wage is now $15.50, and the small employer phase-in has ended. So if you're a small employer and you were used to every year the last few years to seeing what the minimum wage was, and in your mind you mentally were adjusting yourself 50 cents down, that has ended. So it's one statewide minimum wage for everyone. And also, just as a reminder, when the minimum wage goes up, the salary threshold that you have to pay someone if you want to classify them as exempt, that goes up, right? Because the exempt employee salary threshold is twice the minimum wage. So this year, the threshold salary is $64,480 a year. And if you were a small employer whose minimum wage was, I guess, $14 an hour last year, that's a big jump. And so I've actually had several clients talk to me about reclassifying exempt employees to non-exempt because they didn't want to give them that big of a, sorry about that, that's my office phone ringing. They didn't want to give them that much of a bump up. All right, if there are any agricultural employers here, we're still phasing in agricultural overtime pay. So for larger employers, 26 or more, they're now paying overtime on the same types of hours that every other employer is paying. They're still in the phase-in stage for your smaller ag employers. So as of January 1st this year, if you have 25 or fewer employees, you start paying overtime after 9 hours a day or 50 hours in a work week. And you'll be up to the same 8 hours a day, 40 hours a work week as everyone else in 2 years. So something to plan for. And then I want to talk about something related to what are the hours worked, right? We all think we know when our employees are working from their time card, but this was an important case that came up last year in the federal courts, but it applies to California because the Federal Fair Labor Standards Act applies to California where it is stricter than California law. In this case, the employees at issue worked at a call center, and they used their computer in order to make the phone calls to people, right? It was like a system that wasn't a telephone. It was a system that went through the computer. In order to access their time and attendance system, they also used the same computer. So many of us have time and attendance systems now that our employees go in and they clock in, but it's on an app on the computer, on some sort of software program on the computer. So the question was, in this case, whether the time that the employees spent turning on their computer in the morning was really time worked that was compensable time. And under the Fair Labor Standards Act, activities that are an integral and indispensable part of the employee's principal activities those are considered compensable. So because their principal activities required the use of their functioning computer, the time that they spent turning on their computer was compensable time. So it was part of their hours worked because they couldn't do their work unless they turned on the computer. So therefore it was integral and indispensable to their duties of making calls. Now, if they had if their computer wasn't integral and indispensable, then there could have been a different result. It wasn't the fact that the timekeeping system was on the computer that was the deciding factor in this case, applying federal law. I would suggest to you that the state of California would definitely consider this also to be time worked. There would be required to under this test, but I think it also could be considered time worked under the state of California laws, even on a looser test than this, because the state of California, as you probably know, is a little stricter in their wage and hour laws, and it's much more employee friendly. So you want to make sure that you are capturing all time worked by your employees, and make sure that your time and attendance system isn't setting up a barrier to capturing that time. And I'm going to look up here in the boxes, the question boxes, and see what the questions are. So do contracted employees, okay, so 1099 employees, so those are not employees, right? If they're getting a 1099, they are independent contractors. Do they need to be paid the hourly minimum wage if their contracted hourly amount is lower than the minimum wage and was signed prior to the increase and the contract is not expired? So that is the type of question that is a little hard for me to answer in a vacuum. You normally would not normally be paying an independent contractor by the hour necessarily. And if you are paying someone by the hour, I would suggest that's a red flag that the person is misclassified and is perhaps not properly classified as an independent contractor, because an independent contractor should be paid for a particular project that they would be doing in their own time and in their own manner. So I would say that's something I would urge you to look at, because normally a contractor's price is not an hourly wage. But I couldn't give you a blanket answer on that question. Let's see. What does exempt salary threshold mean? Okay, that's a really good question. So we have two types of employees, exempt and non-exempt. And our non-exempt employees are what typically, but not necessarily, people think of as people who get paid by the hour. So that would be someone who, most employees are going to be hourly or not exempt. And what they're not exempt from is certain wage and hour laws, like your meal break periods and keeping track of your time. So things like that, overtime. So an exempt employee is exempt from certain wage and hour laws, such as tracking your time, being paid overtime, getting a certain meal and rest break. And there are tests that you have to meet if you want to make someone exempt. And those tests are laid out in your wage orders. And if you don't know what your wage order is, I would say, if there's like top 5 things to come away with in this seminar, then would be, you need to know what your wage order is. You need to read it and understand it and make sure you're applying. It's the basic building blocks of what your wage and hour regime should be. And you're going to find your wage orders on the Department of Industrial Relations website. Just type in DIR wage orders and it'll come up. And there's different wage orders for different businesses. Some cover an entire industry. And if you don't have an industry wage order, then you need to look at the occupational wage orders. For example, in the construction industry, there is not an industry-wide wage order. There's wage order 16, that covers people in construction occupations that are out in the field, but then people who are in occupations working for a construction company, but working maybe in the office, are going to be under wage order 4, which is the professional, I don't remember what all else, clerical or something. So but you need to find out what your wage order is. And you'll see the different tests for who can be exempt. And one of the tests in every classification of exempt, one of the things you have to meet is that the person has to be paid twice the minimum wage. And so they could be running they could be the president of the company, but if they don't make twice the minimum wage, they still have to be paid as a non-exempt employee. They have to track their time. If they work more than 8 hours, they get overtime. So it's very important to understand the difference between exempt and non-exempt. So good question. And please go look up your wage orders after we're done with this seminar. Now let's see, we've got some other questions. Are there compensable wage implications for phone calls made by employers to employees outside work hours? Oh my gosh, oh yes. And I see that problem all the time. So if you call your non-exempt employees after hours, then it's not after hours because now they're working hours. You just put them to work. If it's an exempt employee, someone that is, you know, a manager or a high-level manager, right? Let's assume they're exempt. Then you could call them all the time, right? I call the other lawyers in my office. They call me all the time, right? On the weekends, at night. I don't get paid more or less because of that. My wages are not, it's not by the time I spend, right? I can work, you know, many hours more than 40 a week. So, but if you have an employee who is not exempt, so it's someone that you have to pay overtime to, if you call them at home for 15 minutes on Thursday night, then you need to make sure that you remind them that they need to log that as time worked. That needs to be on their time card. Absolutely. Very good question. Another question, I know that some contracts include an hourly rate for certain services provided within the contract, not just a contract for a single project. It could be, I think we're talking about independent contractors again. And yes, it could be. I'm just saying sometimes if you're paying someone an hourly rate, that's a red flag because you have a pretty good chance that the person is really an employee. But it's not a blanket rule. That's why I said I can't answer the question about the independent, the 1099 folks in a vacuum. It's very fact specific. Okay, so okay, so I'm getting the hang of how to work this gizmo here, I think. All right, now moving along. Oops, sorry, I'm not the most technological guy here. Okay, so moving on to discrimination, harassment, and retaliation updates. A couple of new laws that went into effect in January. A new law went into effect January 1st that prohibits employers from taking any adverse action against employees who either refuse to report to work or who leave work when there's an emergency condition. And the law also prevents employers or prohibits employers from preventing employees from accessing their mobile device in an emergency. So if you wanted to use your phone to call and find out the status of someone's safety in your family when you've gotten word that there is a flood evacuation order in your neighborhood, your employer cannot prevent you from doing that. Oop. Sorry. One good thing to know is that the statute specifically says that a health pandemic is not an emergency condition. So it's for things like wildfires and also, unfortunately, for crimes being committed in the school, right? So if, God forbid, you got a notice that your child's school had a shooter, right? You would be allowed to leave work and you would be allowed to use your cell phone to try to get information on the situation. All right. Now, pay transparency law, a lot of changes on the pay transparency law. So part of this applies to only bigger employers and part of it will apply to everyone. So, so pay attention. So the first thing is if you have 100 or more employees, you need to submit a pay data report to the state of California Civil Rights Department. And you're going to have in your report the median and mean hourly rates for various combinations of race, ethnicity, and sex within each job category that you list. Fortunately, there's a template available for that on the California Civil Rights Office website. They are due every year before the second Wednesday of May. And if you're an employer of this size, you're already doing a similar report to the federal EEOC. And so they've given it the same deadline. So you'll be able to manage that easily, but you have to remember that you've got to submit this separate report too. Now, all employers of all size must provide the pay scale for a position upon reasonable request by an applicant and also to current employees who reasonably request. Now, I want to be clear because I've had a lot of clients ask me this question. This does not mean that one employee can ask what another particular employee is making. So, for example, I'm running a supermarket and one of my cashiers comes over and says, what is, Susie Q making per hour? My fellow cashier. I do not answer that. You should never disclose some particular employee's financial information, including what they're being paid. What I can come and ask you is, hi, I'm wondering what the pay scale is for the cashiers in the supermarket. And so then you're going to go back and you're going to look at all the people who work as cashiers, and you're going to see that some are making $15.50 an hour, some are making $22 an hour. And that might be because of different reasons, right? Maybe they've worked there longer or they're better cashiers, whatever. But the answer to the question then is probably $15.50 to $22 an hour. And that's what that's the information you're going to share. Now, if you have at least 15 employees, you have to provide the pay scale information in any job posting that you make. And if you give the posting to a third party, you have to make sure that they include that information in there. So you're going to see now in every ad you see, assuming the person advertising has at least 15 employees, you're going to see people's pay scale for the position. And then also everybody, all size employers, you must maintain a record of the job title and wage history for each particular employee. Okay, not for each position, but each person throughout their employment and then 3 years after it ends. Now, as you, I hope already know, you have to keep payroll records for 3 years. So when someone leaves, you still have to keep them for 3 years. So this is going to be, kind of part of that. And this isn't really hard, right? Normally in a person's personnel file, you're going to find a notice of every wage increase and what their job title is. But if you don't have such a document, then you're going to need to create that and make sure you have a way to maintain this. And the law defines pay scale to mean the salary or the hourly wage range that the employer reasonably expects to pay for the position. So it doesn't mean that as time goes on, you couldn't pay somebody outside of what you posted or what you stated, but at the time you give it, you want to be reasonably sure, and you don't want to, say that somebody that tops out at $15 or $22 an hour, and then the next week, hire somebody at $25 an hour. You want to give a real answer and make sure that you're kind of staying within that range. But it's not going to be a situation where nothing will ever change based on what you said to one person. Okay, but you want to keep that in mind as you answer those questions from employees or applicants. Okay, now I'm putting this in now as kind of a heads up, right? But this law passed, but it doesn't go into effect until January 1st, 2024. And in January of next year, you will not be able to discriminate based on a person's using cannabis off the job or and away from the workplace. And this is why I'm putting this in advance. If you're requiring drug screening tests, they are going to be illegal if they detect the presence of blah, 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 this big, long medical thing, right? And so right now, what you want to do is take steps in advance of January 1st, 2024, to make sure that whoever you're using to do your employee drug test, that they are taking steps to make sure that their screening tests are going to comply with this new California law. There are exceptions from this law for employees in the building and construction trades and employees who have other testing regimes. For example, if you are running a trucking company, right, and you have truck drivers who are subject to the Department of Transportation regulations, those employees are subject to random drug testing, and that federal law will still supersede the requirements of this law. All right. Also, you know that big list of protected categories that you all have in your discrimination and harassment policies in your handbooks. And it says you can't discriminate on the basis of sex, race, gender, military status, all those things. We're adding another thing to that list. And the thing we're adding now is reproductive health decision-making. So this is one of the items that's going to require you to amend your employee handbook. If you do not have an employee handbook, I like right after look up your wage order. I urge you to make sure that you get a compliant employee handbook. It will solve many problems for you because people will have one rule book to look at. It will also, as you go through the process of putting together your handbook, you will uncover lots of other things that you are doing wrong that you will be able to fix before you have an employee making a claim. So this would be something that you need to update in your handbook. It also, the law also expands required health plan coverage for contraceptives. So if you have a health plan, you should talk to your benefits broker about that. And then there are new posters. Of course, there are new posters every year, right? So this year there's a new EEOC poster that supposedly is a little in language that's a little clearer, more layman's language. The most interesting thing about it is that it has a little QR code now, those little black boxes that you hold your phone up to and it does something. And the helpful thing that this does is your employees can just go up and use that QR code and it will just open right up to the page that tells them how to file a complaint against you, their employer. So anyway, make sure you order all your posters. Those are usually ordered, from a company that will have a whole bunch of everything's all in one poster, right? Because there are so many of these posting requirements, but make sure you stay up to date with that every year. All right, now I'm going to look at the questions for that section. Okay. Do we see a problem with the following policy? If an exempt employee is absent for 4 or more hours in a workday, the absence or half day will be deducted from the available accrued vacation. That is perfectly acceptable. And that's a good question. So exempt employees, the rule is if I'm an exempt employee, so I'm a manager or high-level employee, I'm being paid on a salary. So I might work 100 hours in 1 week and I might work 30 hours in 1 week, but I get paid the same amount. So the question is, okay, well, if you only work half a day one day, you're still getting paid for your whole week's salary. If I have accrued vacation, then what this person is asking is, can I deduct that from my exempt employee's vacation bank if the guy only works for 2 hours one day or less? What can happen is the exempt employee knows that the law requires that if he works at all during the work week, he gets his whole weekly salary. So you could work 10 minutes every day He's really on vacation, right? But he works 10 minutes a day. So he still gets paid his whole salary and he never loses any of his vacation. The law does allow you to make a deduction for a half day worked. You should never nitpick, like take an hour or half an hour, because the definition of an exempt employee is someone who doesn't get paid by the hour. But the half day deduction has been accepted by the courts. And so that is kind of the rule of thumb. You're safe if somebody works less than 4 hours, you can deduct that 4 hours from their leave bank. You cannot deduct it from their paycheck. If they've used up all their vacation that way, you can't deduct it from their paycheck, but you can at least take it out of their leave. Okay, how long must an employer keep an employee's personnel file after the employee is no longer with the company? Ooh, see, that's something I should know off the top of my head. I think it's also 3 years. But I know what we recommend for people to do is that you should at least keep all payroll and personnel files for 4 years after termination, because that's the statute of limitations on certain types of wage and hour claims and other types of claims. So we like to tell people to keep them at least 4 years. But I can't remember off the top of my head, I'm sorry, what the real answer in the labor code is to your question. I think it's in labor code section 1198.5. All right, so answered all those. Okay, so I think, oh, what if they have used all their PTO? Well, then you cannot make a deduction if the exempt employee has used all their PTO and they only work 2 hours in that day. You can't make a deduction from their salary. There are very limited exceptions for when you can make deductions from an exempt employee's salary. And so I can't go into all that right now, but you would need to look at those and see if they fall into one of those types of exceptions, but they're very limited. Taking salary deductions from an exempt employee is, I would say, fraught with peril. So I would be very careful before you did that, and to make sure that it's one of the exemptions that exists. All right, is there ever an amount of hours considered excessive for exempt employees? Nope. That's a matter of just whatever. The exempt employee is never told you must work 100 hours. The exempt employee is told you must get X, Y, and Z done, right? They have job duties, and if it takes them 100 hours to meet their job duties that week, that's okay. And if it takes them 30 hours the next week, that's okay. That's just a matter of having a job description and negotiation with the exempt employee. All right, one more question. I have too many accrued vacation hours. I'm assuming you mean not yourself, but you have a big outstanding liability of employees' accrued vacation. HR said I could move some hours from vacation to sick leave, but my boss, oh no, you mean your own. Okay. Oh, a public employee. Okay. I don't know. I don't know. Public employees have very different, sick leave and catastrophic sick leave banks and all sorts of things. So I can't answer that. I don't know. Sorry. All right. So leaves of absence. This is a brand new leave of absence that you need to know about. It's a protected leave of absence, like other protected leaves. So now California employees who work for people with at least 5 employees are entitled to a bereavement leave. It's an unpaid leave, and it can be paid. They can use other benefits though, right? If it's an unpaid leave, then they could use their sick leave or accrued vacation time. Of course, the employer can make it a paid leave if they choose to, but the state is not requiring that. You are allowed to request documentation, that there was a death or when the funeral is. And the bereavement leave doesn't need to be taken consecutively, but it has to be completed within 3 months. So say, for example, there's a death in my family, I'm upset. I'm going to take the next 2 days off just to, grieve and recuperate. And then the funeral is the next month, right? I could take 2 days off for the funeral the next month. So it doesn't have to be all together, as long as it's within 3 months of the death. Then a change in the California Family Rights Act and paid sick leave. Okay. So you probably know that there's always this growing list of people for whom I can take a protected leave of absence under CFRA or for my sick leave if I need to take care of them, right? If my family member has a serious medical condition or my family member is just home sick that day, I can take leave under one of these two laws. So the new change is that it's not just for my family members, but I also have a right to take CFRA leave or use my paid sick leave to care for a designated person. And that person is not someone that I have to choose in advance. It's someone I designate at the time I ask for the leave. But I can only have one designated person per 12-month period. Now for sick leave, it's anybody. It just says any designated person. For CFRA, it's a designated person that is in a family-like relationship with me. So it's a little more narrow for CFRA than for the regular paid sick leave. Again, that needs to be updated in your employee handbook, and the bereavement leave, you would want to add protected leaves like that. And you don't have to add them all in because some of them don't apply to very many people, but it's really good to have generally applicable ones in your handbook like bereavement leave. All right, so let's see if we have questions on leaves of absence up here. Oh, how about private employees? I think that was about the mingling of vacation and sick leave. Private employers are not required to give paid vacation. And so employers are allowed a fair amount of leeway with what they want to give for vacation. So there's not really a comparable situation as to what you just were asking me about. But all right, we're going to move on to workplace safety. So this is some kind of just for you to be aware of things, because this is relating to your workers' compensation, and your comp carrier will handle this stuff, but it's just good for you to know some of these things. So the time frame for employers to investigate compensation claims has been increased. But again, your carrier normally is the one who's going to carry out the investigation, right? Penalties, if you unreasonably deny claims, are increased. Again, it's your comp carrier who generally says whether things are going to be denied, but the penalty is on you. So you need to make sure you're on top of that with them. And if people have a temporary disability that's presumed for people with cancer, the duration of that has been extended. COVID-19. No, we're not done with COVID-19 yet. So certain health and safety posters about COVID-19 now need to be posted in additional languages. So you want to make sure you have, again, all your required posters. And the COVID notice that you have to give to every employee when they're exposed in the workplace, this law has made some changes to that. First of all, it extends the provisions through January of next year. So we have another year now of doing that. But the good news for employers is that instead of having to give a written notice to every employee, you can now post the notice at your work site and on any existing employee portals. So, if you have an intranet or you have bulletin boards where you normally provide information to employees, you can use those. So we'll make it somewhat less burdensome on you when you have to give notice of an exposure in the workplace. Also extended for one more year, the rebuttable presumption that an employee's illness resulting from COVID-19 was sustained in the course of employment for purposes of workers' compensation. So it's just a presumption that you can try to overcome. So, but the current default rule is if an employee gets an ongoing illness from COVID and they're going to be off work for a while, the current presumption is that it's going to be on your workers' compensation policy. Now, you can rebut that if you have evidence that the employee was at a party on Saturday night, and when he came to work on Monday, he was exhibiting symptoms of COVID and tested positive, and 25 other people at that party also had COVID. You know, you can overcome it and show, look, he got it at the party. He didn't, it's not a work injury, but it just extends the presumption that it's a work injury. And then finally, 3 years into COVID, Cal OSHA has now adopted a non-emergency standard. And it actually just became effective yesterday when it was approved by the Office of Administrative Law. So there was some good news actually in the non-emergency regulation. I mean, the first thing is that emergency regulation that we've been living with, right, was changing all the time as conditions changed, which, you know, I mean, that made sense. But the non-emergency regulation now is expected to stay in place, and we shouldn't be seeing all those constant changes. So it'll be easier for employers to stay on top of things. The good news is that exclusion pay is removed. Now, you still have to provide notice to people when they are excluded, if you're excluding them because they've been exposed, right? That they can still use their sick leave, or they may even have workers' comp benefits if they get sick. But you don't have that just sort of mushy duty that was there for a while to make up all their pay if they were excluded. Also, if you have an outbreak at your work site, all those extra protocols that you had to put in place when you had an outbreak, those can now end if you have one or fewer cases in a 2-week period, instead of having to get it to 0 for 2 weeks. So that's nice. And finally, just again, to kind of ease up on documentation requirements, every employer has to have an IIPP, right? That's the Cal OSHA Illness and Injury Prevention Plan. And all employers have to have a COVID prevention plan. So now you can have that all in one document if you like. And if you do not have an IIPP and you do not have a COVID prevention plan, you must get one. If Cal OSHA comes to your door, that's what they will ask for. And if you don't have it, you're already in violation. And it's not as bad as it sounds, because believe it or not, there's actually a very helpful tool on the Cal OSHA website, and there are tools for employers on how to create your IIPP and how to create your COVID prevention plan, and they have templates. So if you don't have those documents, then please go on to the Cal OSHA website and look at that information and get those put together so that you're not getting dinged if they come knocking on your door. Okay, now the regulation also retains the definition of close contact that was adopted last summer. So we all got used to, for a long time, that like 6 feet apart thing, right? And so last summer, the Department of Public Health, they kind of tweaked that. So the current definition is for indoor spaces that are larger than 400,000 cubic feet per floor. So like the big spaces, that still has the 6 feet part. So 6 feet, 15 minutes over 24 hours. But for smaller spaces now, the definition is somewhat different, and it's sharing the same indoor space as someone with COVID for 15 minutes or more. So it doesn't have the 6 foot part. It's the same indoor airspace, and you have to look at there's additional information on how that's defined in the regulation. I strongly recommend that you read the entire text of the new regulation, and you go on your Cal OSHA website and you look at their fact sheet. And when you get this, I've got links here to it. But it is really, I think employers are often surprised to see how much very helpful information can be found on these government department websites. There are whole sections of wonderful resources for employers. If you look at those fact sheets or their FAQ sections, you will be able to get a lot of very helpful information that will help you to stay on track with the law. All right, so let's check the Q&A box now. Is there a service that you or others provide to audit handbooks for compliance? Yes, it is something that we do all the time, is update our clients' handbooks or draft handbooks, or audit people's handbooks, absolutely. And other employment law firms would do the same. Sometimes people get handbooks from their payroll companies. I've never, and this is nothing against payroll companies, but I've never seen one that's compliant with California law. So I highly recommend against adopting one of those without having a lawyer look it over. But yes, it is very important to get your handbook done. Into which languages must the posters be translated? I don't know the list off the top of my head. You'll have to, if you go and look on the Cal OSHA website, it'll tell you, and whoever you order your posters from, it'll be, you can double check it, but they're usually on top of those things. Does the employer need to inform employees where the employer will be posting exposure notifications? It's supposed to be on the existing portals that you use to communicate with your employees. So it should be where they know to go and look, but I think it's always better to give people more information. I don't remember off the top of my head whether the regulations say something that specifically requires that. To my knowledge, they don't. It could be there. I don't remember that off the top of my head. But I think it's always good to tell people that if they're used to getting it in a paper notice and now you're going to be putting it on the portal, I would let them know, right? No, it's better to let them know. Oh, we have several portals for communications. So you could put it in all of those different places. Okay. Now, what else? Is it possible to contact you after the webinar? Oh, yes, of course it is. And I think that my info is going to be at the end of these slides. I do this as SCORE for a volunteer, and obviously I'm happy to help you afterward, but the purpose of the presentation is to give the presentation. But I do think my contact information is on the end of the slides. I'm happy to talk with any of you. Okay, let's see. I'm just making sure that I have all these little. All right. Oh, wait, there's one. As a one-person company where I am the only employee, is there any repercussion of not taking vacations, sick leave, PTO with any government agency, EDD, etc.? Not taking them. Okay, I'm gonna give my best guess as to what this is asking. So you're a one-person company. When you say company, if you mean I'm not sure if you mean you're a corporation or a sole proprietor. If you have I think what you're saying is you have no employees, so you don't have to give yourself, well, nobody has to give you paid vacation or anyway. It's funny, I want to say, oh, you're an S Corp. Okay. I'm not sure how the paid sick law exclusions are set up. If you're an S Corp, I'd have to go and look that up. But I rather suspect that you do not have to give yourself paid sick leave, but I'd have to double check that. All right, employee arbitration agreements. This also has been an area of the law that has been in flux the past year and a half. And we don't have time, and you don't really care about all this legal ins and outs of these very Supreme Court cases, but suffice to say, there was a big Supreme Court case last summer that was good news for California employers, and that allows arbitration agreements between employers and employees to cover the individual employee's claim under what's called a Private Attorney General Act. And if you've never been subjected to a Private Attorney General Act or a PAGA claim, that's good news for you. But it's a type of representative claim, and it can really cause a lot of, expense and difficulty to defend for a California employer. So if you have an arbitration agreement with your employees, the good news is that your PAGA, part of the PAGA claim, will be covered by your arbitration agreement. It's unclear what happens to the representative portions of the claim. So the PAGA employee is bringing a claim for civil penalties on behalf of himself and all of your other non-exempt employees. And right now, the California State Supreme Court is trying to decide what happens with the rest of it. The main thing that you need to know is that you want to have an arbitration agreement with your employees. Some employers have included that in years past as simply a section of their employee handbook. Now, we haven't done that in years and years and years. It's been clear that that's a poor idea. But there was actually a case that just came out last year where the court said that's not a legally binding agreement if it's just in there. It needs to be a standalone arbitration agreement that you want to have with your employees. We highly recommend that you have an arbitration agreement signed by each of your employees, because it will prevent them from filing a lawsuit against you in most cases. There are lots of exceptions in certain types of things that cannot be subjected to arbitration, like unemployment claims or certain things that can be taken out of arbitration, for example, in certain types of sexual harassment situations. But overall, you want to have an arbitration agreement, just like you want to have your employee handbook. Okay, now let's see what else we have up here. Okay, all right, so benefits. Just a brief note, I'm not a benefits attorney. I do have a colleague here who specializes in employee benefits, but I want to mention this again to you so that you all know what the law is now and what's coming your way. If you don't already offer a retirement plan to your employees, then you need to pay attention to this, because the Cal Savers program is going on, and now employers with 5 or more employees are required to register for the Cal Savers program. That started last June. Starting in December of 2025, so you still have a ways to go, that's going to be basically everyone, right? Threshold is going to be reduced to 1 or more employees. Now, what the Cal Savers program is, in brief, is it's an IRA savings plan, and your employees, once you register, your employees are automatically enrolled unless they opt out. So the opposite of how we are used to doing it, right? So it's just a way to encourage people to save for their retirement. And if your company doesn't have its own, if you don't have a 401k plan or whatever other kind of retirement plan, then you're going to sign up. You need to register with Cal Savers. So you want to pay attention to that. Talk to your benefits broker about that if you need to. Oops, I do that every time. Okay, now let's see. Okay, with Cal Savers, is it still okay for employers to have a 2-year waiting before they contribute? I don't know. As I said, I am not a benefits person. I put that in so you guys are aware that there are requirements to register for Cal Savers. What the ins and outs of 401k plans and all that stuff, I don't know. That's not what I do. That's too much tax stuff involved in there for me. But good question. You'd have to ask a benefits attorney that, or your benefits broker might be able to help you. Okay, now's my favorite part. Let me check the time. I think we're doing okay on time. The top 5 things that we thought all employers knew but learned they didn't this year. All right, number 5, no time banking. Compensatory time, sometimes called comp time, is illegal in California. Please look at that. See there, it said that up there in bold. Comp time is illegal in California. People do not seem to know that. So this year I had an employer who was allowing their employees to what they call bank their overtime hours, and they would cash them in later when they wanted to go on and take vacation. They didn't have paid vacation. So let's say I worked 5 overtime hours this week. Instead of getting paid my time and a half for those 5 hours, I would put those 5 hours in a bank, and they just like literally had a, a log. And then I wanted to take 3 weeks off at Christmas, and I still want to get paid. So then I'm going to cash in my bank. And the employees actually were perfectly happy with the situation. And so they wanted to have that, steady income over the course of the year. But that's just an illegal compensatory time system by another name, right? You have to pay all wages, including your overtime wages, by the next pay period, unless it's a makeup time situation, which is something that an employee would ask for. It has to be time that's adjusted within the same work week, so that, let's say I have a doctor's appointment today and I need to leave at 4 o'clock. I'm going to miss my hour's pay from 4 to 5, but I need that hour's pay. So I say to my boss, I have to leave an hour early today. Could I work an extra hour tomorrow to make up for it? And the boss is thinking, well, no, because then you're going to work 9 hours tomorrow. So I'd have to pay you time and a half for that 9th hour. Makeup time allows, in that particular situation, when the employee asks, not the employer, it has to be the employee's request, they can ask to work an extra 1 or 2 hours, not more than 10 hours in a day, to adjust. So they'll still make that same amount of money, and it has to be in writing. Other than that, don't do that. Okay, number 4, no use it or lose it vacation. You cannot have a paid vacation policy that provides for the loss of unused vacation, right? So if your vacation policy says, any vacation, if at the end of the year you still have vacation on the books, it goes away, we take it away and you start over next year, that's illegal. Those are considered wages. Your vacation hours are considered wages. So you can avoid having a big old vacation liability on your books. If you have employees who they just keep on accruing, and they never take their vacation, then when they leave, you have this big payout, right? So we don't want that. So you can solve that problem in one of 2 ways. The most common way is to have an accrual cap. So your policy would say, like, okay, everybody gets 40 hours a week or a year. 40 hours of vacation a week would be nice, but 40 hours a year. And then you're going to accrue, usually it says up to 1.5 times, so 60 hours. And if you get to that cap, you're going to stop accruing until you drop below. So if someone doesn't take vacation for 4 years, they still only have 60 hours on the books that you have to pay them out when they leave. The second option is to pay out the vacation balance at the end of every year, which is perfectly legal. It's costs the employer more. You're spending money, you're giving money to people you don't need to. Employees, of course, they like that policy. You can do it. It's a morale booster maybe, but you also want to make sure too that people are encouraged to take their vacation, because in the long run, you're going to have more productive folks. But no use it or lose it vacation policy. Do not allow people to alter employee time records without the employee knowing about it and approving of it. So I had a client with a bad actor this year. The supervisor of a crew of employees who was charged with making sure that they took their meal and rest breaks on time, right? So they took them as a crew, and he was supposed to make sure that they took their lunch at the appropriate time, which the law requires that you have to take your 30-minute meal period. You have to start it before the end of the 5th hour of work. Well, sometimes the supervisor wouldn't want to do that for whatever work. He wanted to finish whatever they were doing, right, before they took their break. So they would take their meal break late. So he knew he would get in trouble if that showed up on the time cards, because if you make your employees take a late lunch, you have to pay them an extra hour's pay. So he knew he would be in the doghouse, because the company would end up having to pay everybody an extra hour's pay. Well, he had access through the computer system to everybody's time records, and he would just adjust the times so that nobody knew they were taking them late. And of course, the workers knew, but they were afraid to go and complain. Somehow it came out, right? But of course, he's a bad actor, right? But we want to make sure our systems are set up to prevent those kinds of things from happening. We can't just rely on having good, honest personnel. We want to make sure our systems are in place. So you should make sure in whatever your timekeeping system is, that if an adjustment is needed to a time record, which happens sometimes, I mean, that's going to happen because people make mistakes, that the employee signs off on it. So the employee can't come back later and say, this is a totally fraudulent time card. And then, you're going to want the supervisor or HR or somebody to sign off on it too. But you can't have somebody going in and changing your workers' time records without the worker being aware of that and signing off. All right. Commission payments. If you have commission employees, first of all, you have to have a written commission agreement with them. So make sure you have that. But you have to pay them out. There's still wages and they have to be paid out in the pay period when they're earned, right? You can't, I had this employer, again, for all nice intentions, and the employees perfectly happy with the system. It was kind of a seasonal type of a thing where there were certain times a year where people would earn big commissions, and there were certain times a year where they wouldn't really earn any commissions. So what the employer did was he kept all the money and he would pay them out a steady income over the course of the year. Sometimes it was really an advance he was paying them. Sometimes he had their money in his bank and he was paying it out to them in installments. It just depended on what, the vagaries of that year and that person's commissions. But at the points in time where he had their commissions and he wasn't paying them, he's breaking the law because he's withholding their wages, even though they know it and are okay with it. You can't agree to do that. So commissions have to be paid out just like any other wages. Finally, this was my favorite. That's why it's number one. You cannot forbid your employees from talking to attorneys or anyone about the terms and conditions of their employment. This honestly was found in an employee handbook that was given to me to audit, right? I almost had a heart attack. No employee shall undertake discussions of any kind with any attorney without the express approval of the company president. There are no exceptions to this rule. When I read things like this, I can only imagine like what happened, right, to get the author of this to this point of frustration where they actually put this in their handbook, and it was there for years. That's not permissible. Your employees are entitled under the National Labor Relations Act to discuss the terms and conditions of their employment. You cannot prevent them from doing that, and you certainly cannot prevent them from seeking legal advice. So anyway, those were the top 5, and let's see now what other questions we have. Can employers apply vacation time to bonuses or profit share plans rather than an increase in W-2 earnings? I'm not 100% sure what we're saying. If someone, maybe if it's a buyout, maybe. I mean, if someone takes vacation, you're going to pay them their vacation wages as part of their normal paycheck. But I'm wondering if what you mean is at the end of the year and you do a buyout, can you not pay them as wages? That's a tax question that I'm not going. My sense is no, they're wages. You can't make them something else. But that's a tax question. I really can't give you a definitive answer on that. You'd have to ask your CPA. Okay. Got 2 more over here. Okay. I am a sole proprietor planning to hire my first employee by the end of March. That's awesome. Where can I get help to do employee handbook? So that's going to be, if you have 1 employee, it's going to be a simpler handbook because a lot of things won't apply to you, but a lot of things do apply. So you should do that. And you can contact most employment lawyers will draft a handbook for you. I have a template. It's not like you do it from scratch, right? So It's really great to get started at the beginning though. There are also human resources consultants who draft handbooks. Maybe I'm biased, but I do always recommend for a handbook that you have at least have a lawyer look at it, even if they didn't do the drafting. What if we have a window cleaning business and the employee has to do service in a residential home? How do we track the time? Okay, good question. How do we track the time of our employees who work in the field, so to speak? So let's imagine the employee doesn't even come into the office. They just go from house to house. So your commute time in the morning is not hours worked, right? It's just your regular commute. So in that case, the employee doesn't really have a regular commute because his first stop changes every day. So his time in starts when he gets to his first, probably when his first job. I mean, there are always different facts. It's fact dependent, but in general, let's imagine he goes straight to his first house. That's when he's going to start working. And so that's when he needs to clock in. Now, how does he clock in? That's up to you. Do you have an app on his phone that he can use to clock in? A lot of people do that. If you do that, you are now requiring the employee to use his personal cell phone for work, and you need to reimburse him for the business expense of that. Or you can give him a paper time card. He can write it down. I start work at 8:02. And now for the rest of his day, he's on the clock. So he's going to wash windows at my house. I wish. And then he's going to go wash windows at the next guy's house and the next guy's house. And he's going to be traveling from time to time. All that's time worked, right? He's still working. At some point, he's going to, before the end of the 5th hour of work, he's going to take his lunch break. And then he's going to write on his time card, or he's going to put it in his app, out at whatever, 11:32. He's going to take his 30 minutes. Then he's going to clock himself back in 30 minutes, whatever time he clocks in, 12:04. And then he's back to work. And then when he finishes at the last house of the day, that's going to be the end of his workday, because now he's just commuting back home. So that's how he's going to be tracking his hours worked. And you can use whatever system you want, but it has to be it needs to be an accurate, legitimate system that the employee is filling out. Okay. So many problems with people not tracking their time. You don't want to be going to the labor commissioner with a bunch of time cards that all say started at 8, went to lunch at noon, came back at 12:30, left at 5. No human being lives like that, right? So don't have that. Don't do that. Make sure they're accurate. That's part of managing the employees, making sure they do that accurately. Okie dokes. If all employees take vacation between Christmas and New Year's, not by accruing, if someone leaves mid-year, do we need to pay vacation pay? Well, you got a lot of potential problems in there. So if you're saying if you just close your office and you give everybody a week off between Christmas and New Year's, it's not really it's not paid vacation in the normal sense. You're just closing your office, and I would call that holiday pay, right? I would say that's a situation we would need to look at the facts more closely, because what you don't want to get dinged for is the court saying, or the labor commissioner saying, you're kind of hiding vacation and calling it something else in order to stiff the guy who leaves mid-year. So that's, I would say, on the line, and I would need to look at that a little more closely. All right, next question. Can we automatically no? Oh no. Wait a minute, let me read the whole question, because I have these auto deducts all the time. Can we automatically deduct half pay? I think she means half hour, even though they take 1 hour for lunch for employees working in the field all day. Well, okay, so do not ever automatically deduct pay. If the pay, time card, whatever the time is it needs to have on there what time the person left for lunch and what time they came in. The labor code specifically requires that employers, it's your job, not your employee's job, it's your job. You have to make sure that you have a time record that shows when your employees start for the day, when they clock out for lunch, when they clock back in, and when they clock out for the day. Your job. If they're not doing it, you need to discipline them for that. That's an infraction of a very important company policy because the law requires you to have those records. Do not auto deduct. I see that all the time for people who are working in the field. They clock them in the morning, they clock out at night, and the payroll people just automatically take out half an hour of saying they were at lunch. You have no proof they were at lunch. That's just a walking wage and hour claim waiting to happen. Now, what I don't understand is, can we deduct a half hour even though they take 1 hour? So that sounds to me like you are giving them a 1 hour lunch, but you want to pay them for a half hour that they didn't work, that you want to give them partially paid lunch. You can do that. You're not required to do that. I don't recommend it because it tends to muck things up. And if you want to pay them more, I think there are other ways you can achieve that. I mean, it's not illegal to pay someone for their lunch, but doing half paid, half unpaid, I'd need to look at the facts, but do not ever, please, nobody automatically deduct from time. Don't do that. Okay, I work in the county government. Yes, public sector's employees are very different, and that is an exception. They do have some kind of comp time thing, but public sector time worked and time off is that's a different world. I have a business client who currently has commissions-based position, where his employees earn $15 to $50 an hour, but as the employee generates commissions, their hourly rate decreases to $12. Is this a legitimate pay structure for commissions-based employees? It depends. That's a very specific question. There are a lot of rules about how commission employees have to be paid. I would need to know a lot more information about, first of all, there's a specific definition of commission. People call things commissions all the time that aren't necessarily under the labor code of commission. So I can't answer that. I would say maybe, but it would depend on a lot of other answers. Okay, anonymous attendee. In your window washer example, what if you're driving a company truck? If you're driving a company truck, okay, I'm gonna make my best guess as to what the issue that you're seeing is. Is the question, if I'm driving a company truck, whether my morning and commute and return home is time worked? And in that answer, if that's the question, I would say it depends. It could be, but not necessarily. It depends why you're driving the company truck and what you're doing with it. So it depends. It could be work time, or it might be non-compensable commute time. If you're asking whether it's hours worked, traveling from site to site, if you're driving a company truck, my answer is the same. It's still hours worked. The real difference is that if you're driving your personal vehicle from window washing site to window washing site, then you now have a business expense that you've incurred. Most employers will reimburse you based on the federal mileage rate. You're not required to do that. It's just kind of a sensible way to do it because it's presumed to be sufficient. And if you're driving a company vehicle, you the employee, wouldn't be incurring that business expense. It's because you're driving a company truck. So that's my best guess as to what you might have been asking. How do we get field employees to clock in and out for lunch when the time clocks are in the office? I get that question a lot from clients. And my answer is, the law requires you to keep those time records. And the labor code is not a defense. I tell this to people all the time. It is not a defense to say, my timekeeping system won't let me do that. You choose your timekeeping system. So as I said, you can do whatever you want. So they could clock in and out for lunch on an app on their phone, and they could clock in and out for the day at the time clock. It's going to make it harder for your payroll people, but you could do that. Or they can clock in and out. They can, as I said, just write it on a piece of paper and hand that in at the end of the week, a paper time card. And if they just do that for lunch, and they're in and out for the day is on the time clock, that's totally fine. You have to find a system that is going to work for you logistically and also comply with the law. What about for home caregivers who can't leave a patient alone to have lunch? So you are, under certain circumstances, allowed to have what's called an on-duty lunch. There are very specific requirements that you have to meet, and the person is paid, right? So that's a very specific issue, but there is a way to provide for that. You have to make sure that you are following all of the requirements for that, and I can't go into all that right now. Okay, okay, so we just answered that. If employees take vacation, oh, we answered that too. And we answered that. Okay, oh, wow. Okay. Okay, we need to wind up. Oh, yes, we do. Sorry, I had a lot of questions. Okay, so here are some resources that our firm provides that are free to you to look at if you want to sign up for our podcast that comes out every month, our employment law newsletter, and other resources for employers. We welcome you to sign up for that. And there you go. Sorry that I went over. We had a lot of good questions. I know I get too excited about helping everybody, but anyway, thank you all for your participation today. And as I said, they will be sending out the presentation slides and the recording. Bye.
Shawn, great job. Thank you. Shawn, can you hear me?